Okay, I'm going to go ahead and get started. I want to thank you for joining us today for legal issues facing business owners. We have our very own David Berman, a SCORE mentor, and be prepared to learn a lot. So this is a very packed webinar with lots of fantastic information. So as we get started, though, I want to tell you a little bit about SCORE in case you're not familiar. SCORE does three main things. One of them is our mentoring, which I'll go over in a moment. The other is our webinars and workshops, training for everyone on many different business topics. And you're going to also find lots of information and resources on the website. So I strongly encourage you to check that out. Business templates you can download, blogs you can read, lots of fantastic information. It's also where you're going to find the recording for today's webinar. So, which I will explain in a moment as well. So as we get going, I want to talk about mentoring really quick because it is the most important thing that SCORE does. Our mentors are volunteers. They come to us with a wide variety of experience and knowledge to share with the business community. Our business community of clients are going to range from those that are trying to figure out if small business is right for them. If we're working with those that are in that planning phase, that are trying to get everything organized and ready to go. And we're working with folks that are already in business. Some have been in business for a couple of months, some have been in business for years. And we are there to help that whole group of folks. A beginning session is going to be a get to know you. They want to know what your goals are, what your challenges are, and they're going to help you formulate a plan to achieve those goals and overcome those challenges. Oftentimes other mentors are brought in as needs change, and you will have a team that's there to support you from, like I said, from the beginning until the day you decide to sell your business. So I definitely encourage you to consider a SCORE mentor. Getting a mentor is very easy. You can use that QR code. You can also go to the score.org website, put your zip code into the little zip code box, and it'll match you to the chapter that's nearest you. And it'll give you a chance to enter what you're looking for, and then that chapter will help find the mentor that can assist you the best. Today's format is we are going to use that Q&A tab. We do anticipate a significant number of questions today. So Q&A tab on the Zoom bar, that's where you're going to put questions for our presenter. Everything else can go into chat, and I'll definitely be watching chat, but it is difficult to keep track of questions. So that I don't lose any of them, please try and put them in that Q&A tab. And as I mentioned before, the recording, give me about 24 to 48 hours. You go to the score.org/Boston website. Under the local workshops tab, previously recorded is where you will find today's recording. So I'm going to go ahead and pull down my share, and I'm going to turn it over to David.
All right.
And it's all yours.
Thank you. Let's see if I get the right window. I do. Okay. Thank you, everybody, for joining. I appreciate it. This is going to deal with many legal issues that you may encounter in starting or running a business. Each issue is sort of broad in scope, and if you need any particular advice, you should reach out to your attorney for specific guidance. One of the lawyer's favorite words is, in answering a question, is it depends, and a lot of time it does depend upon what the facts are and what you're trying to accomplish. And of course, you can always reach out to SCORE mentors to go all alternatives with you. That being said, let's jump right in. And the first topic that I'd want to address is licensing to conduct your business. There was a webinar a couple of weeks ago about forming business entities, which talked generally about forming corporations, LLCs, and if you were going to operate as a sole proprietor. But beyond that, there are certain businesses that are required to be licensed. or approved by the municipal and state authorities. For example, if you're in a profession, doctor, or pharmacist or something such as that, attorneys, how can I forget that? And massage therapists, electricians, there are state licensing requirements that you will have to comply with in order to conduct your business. In addition, certain things need local and state approvals. For instance, if you are selling liquor, you'll need, whether it be in a tavern or in a retail establishment, you'll need an alcoholic beverage license, which you go through your town or city and then get state ABCC approval. So you will need those types of licenses. If you're a retailer, you'll probably want to get a sales tax exemption license, which basically says that when you buy your goods from your wholesaler, you're buying them for resale to the public, so you don't have to pay sales tax on your purchases. The ultimate consumer, when he buys your goods, will pay them, but you do need to get approval for that. Other licensing or approval issues, obviously, if you're doing any building or you're opening a business, you should check the zoning laws to make sure that the site that you're operating from is an approved site under the zoning code, or you may need to get a special permit or a variance to allow the business to operate in that location. Similarly, there are conservation areas where you may need conservation approval in order to construct on it, and there will be limitations put on your contracting there. And of course, if you're building something, you need a building permit, and you'll need building inspections and sign-offs every step of the way. So, there are a lot of permits and licenses that you should consider. Many of them won't impact you depending upon the nature of your business, but they are items that you need to consider. Jumping into leases, we get lots of inquiries regarding leases, reviewing leases and the like. And the first thing I always mention to the client is this a good location for you? Forget about what the terms of the lease are. Is this a good location? If you're a retail establishment, is it visible from the street? Is there parking for your customers to park in so that they can solicit your premises? So what is the other competition? Are you opening a drugstore next to a CVS pharmacy? Probably not a good idea. But the first thing really in leases is your business, and making sure that this is a good location for you, where there's going to be foot traffic if you're in retail, where there's parking and other services that you need. Obviously, some businesses, location is less important. If you have a construction company, you need a yard to store your trucks, and to have a construction office, you probably don't need to be on Main Street of your town. You could be at some other location, but then again, you need to confirm with the zoning that your proposed use of the location is good for what you're trying to do. People will often hear the term triple net leases. And what a triple net lease means that you pay a monthly rental, whatever it may be. Let's just call it $10,000 a month for the space. And then in addition, there are add-ons that you have to pay. You may have to pay a portion of the landlord's real estate taxes, a portion of the landlord's insurance costs, common area charges if you're in a mall for cleaning and maintaining the mall, snow plowing, and so on and so forth. So when it's a triple net lease, that really means for the landlord, he gets his monthly rent check from you, and all the other expenses are shared amongst the tenants in the building. So when you're calculating your rent for cash flow purposes, you need to not just put in your monthly base rent, but put in an estimate of what the additional charges would be. The additional charges are usually allocated on a percentage basis, so that if you're in a 10,000 square foot building and you're occupying 1,000 square feet, then you'd pay 10% of the other bills. if you're able to, in some cases, you're able to negotiate with the landlord to say, I'm not going to pay 10% of all the taxes. I'll just pay 10% of any increase after the date that I come in, because, you know, the existing taxes probably are calculated into the rent. So you try to limit your obligation for these items to any increase in costs that the landlord has. That sometimes is possible. But that's what a triple net lease is. Its terms just thrown around a lot, and I just wanted to make sure people understood what it was. Then you have to consider whether you're going to have a tenancy at will or a term lease. A tenancy at will basically means that in 30 days notice, the landlord can evict you or you can leave by notifying the landlord 30 days in advance. So the benefit of that for a small business is you don't have a long-term commitment. If your business doesn't work out, you can leave without a long-term rent obligation. At the same time, if your business is successful and you like the location, you want to stay, the landlord can remove you on a 30 days notice. So there are pluses and minuses to the tenancy at will. A term lease would be just as it sounds. You'd rent for a period of a year, 2 years, 3 years, 5 years, whatever term you can live with and negotiate with the landlord. But, you know, if you breach the lease, your business doesn't make it, and you have a 5-year lease, and after 2 years you say this isn't working, you're still going to be liable to the landlord for the remaining 3 years of rent. So that's the compromise if you want a term versus a tenancy at will. One thing you also need to do is before you went into the lease is to see if you're going to take the premises as is with no changes, or whether you're going to have to build out the space or partially renovate the space, and then decide whose obligation it is to undertake that work, whether it's at your cost or whether the landlord's going to upfront the cost, and obviously the landlord will try to recoup that by charging a little higher rent. But you know, this would necessitate not only just looking at the space and saying, yeah, the square footage is good, but if you want some modifications, you need to put in the lease exactly what modifications the landlord is doing at his expense. And the lease will probably say that you cannot alter the premises without the landlord's consent. So if you're doing things on your own, at your own expense, you should get the landlord to sign off before you sign the lease saying, these are acceptable changes to the premises that you can undertake. You know, and in connection with renovating the premises, depending upon the extent of the renovation, you may need to hire an architect or somebody to draw up plans to show exactly how it's going to look when it's done. But you need to be very specific in the lease in terms of what construction obligations are and who's paying for them. And you probably want to make sure that you don't start paying rent until the premises are ready for your occupancy. So if the landlord's doing the work, you won't want to pay rent until the landlord gets you a certificate of occupancy and the work is completed. If you're doing the work, the landlord probably won't want to give you an unlimited time, but you should negotiate with the landlord to say, all right, it's going to take me 90 days to do this work. I don't want to start paying rent until I open for business. So, you know, 90 days is rent free. But those are things to consider when you talk about construction of premises. Use limitations. These mostly comes into impact in terms of a mall usage. For instance, if in the old days Sears was an anchor tenant and Macy's was the other anchor tenant, and there were other tenants in the premises, the landlord may not want you to use the premises in competition with their other tenants. So that if you, and you can try to negotiate this for yourself depending upon your leverage and power in the transaction. So for example, if you wanted to run a CVS in the premises and there was already a Walgreens in the mall, the landlord may have prohibitions in the Walgreens lease that it will not lease to somebody else in that same business, and you'd be limited. And sometimes the use limitations are geographic. So the landlord could say, you can't open a CVS within a mile of my mall because it doesn't want to divert from the Walgreens that's in the mall. So you need to carefully review the lease to see if there are any use restrictions. Oftentimes the landlord will put something in that says you can use the premises for the conduct of a restaurant, for example. But if you decide you wanted to do something else other than a restaurant, you wanted to have a bakery with takeout goods, you may need landlord's approval to change the use. Options to extend. Leases generally run for a set term. As a new business or a young business, you may not want to have a 15-year lease because of the financial obligation. You may want to see if you're going to make it. So on the other hand, if your business is running successfully, you may not want to leave after a short term. You may want to be able to stay there for a longer term. So the way to address this is to do a short-term lease. For instance, do a 3-year lease, and then you'll have an option to extend for successive 3-year terms. So say within 6 months at the end of the first term, say 2 years and 6 months in, you can say, I want to stay another 3 years, and the lease will automatically be extended for another 3 years, either at a pre-negotiated rent that's in the lease or at some other rent that the lease will provide. And as long as you're not in default. Obviously, if you're in arrears in the lease or doing something in violation of the lease, the landlord doesn't have to extend. But this lets you use the premises for a longer term without the long-term obligations, because every 3 years, if you had a 3-year lease with 4 options to extend for another 3 years each, you could every 3 years decide, I want to stay for another 3, or I don't want to stay for another 3. So that is a good way to try to not end up in a long 10-year lease. I had one client, score client, who wanted to do just that, 3-year lease with 4 options. And the landlord said, either you take a 15-year lease or we don't have a deal. So they didn't have a deal because the client didn't want to commit to 15 years. Options to purchase, right of first refusal. It may be at some point that the landlord decides to sell the building or sell the mall. Unlikely if it's a big mall like South Shore Plaza or Burlington Mall that you're going to want to buy the mall. But if it's a single purpose building, let's say it's a condominium office building and there are 3 condominiums in the building and you occupy one for your office, and the landlord says, I want to sell, you may want to have something in the lease that says, that you have the option to buy it if the landlord goes to sell it, on the terms to be set forth. Or one client had a lease that said after 8 years in the lease, it was a 10-year lease, they could buy it for a fixed price. So if you're interested in possibly acquiring the premises down the road, you could try to build an option to purchase or right of first refusal into the lease. I'd say a lot of the clients I deal with at SCORE aren't looking necessarily to have that right because they're small and they're just starting up. But if there's a possibility that you may want to stay there and you want to buy the building, something to negotiate with the landlord. Assignment limitations. Most of your leases will say that you cannot transfer the lease to a third party without the landlord's consent. The purpose of that is the landlord wants to know the person he's leasing to, and that the person he's leasing to has the financial wherewithal to pay the rent and perform the obligations under the lease. Furthermore, the landlord may not want to, even if there isn't a use restriction, he may not want to agree to assign the lease to somebody that's in competition with somebody else in his mall. So, a lot of people come to me and say, I'm having trouble. Can I sell my lease or transfer my lease to this other business? And the answer usually is you can, but you need the landlord to sign off on it. Um, in the unusual event that you fail to comply with the terms of the lease, the landlord will have the right to evict you. That is not necessarily something we should look to negotiate, but when he can evict you and what he can recover from you are things to negotiate. For example, if your rent is due on the first day of the month and it gets there the second day, the landlord shouldn't have the right to evict you. There should be some sort of grace period built in that if you don't pay rent within a period of time after the due date, then he can evict you. We like to build in, if we can, that it's, say 10 days after you receive notice from the landlord that you haven't paid. Now, that's a little harder to negotiate than just saying 10 days after the due date, because the landlord says, when the rent's due and if you paid it or not. But as to non-payment defaults, that the landlord says, for example, that you're not keeping open for business as required under the lease, that you've done something in violation of the lease, you haven't maintained insurance or whatever it may be. We usually like to say that the landlord will give you notice of the violations, and you'll have a right for 30 days to fix the violation. And some violations can't be fixed in 30 days. So we like to add to that says, if the violation can't be fixed in 30 days, but you are pursuing it and you're diligently pursuing to remedy it, that the lease can't be terminated and you evicted. So in a lot of these situations, what we're really saying is it shouldn't be an automatic eviction. If you hiccup, the landlord should give you notice and time to fix it. And then assuming that you don't fix it and the landlord wants to evict you, the question is, what can he recover from you? One thing that you want to build in the lease is that if the landlord displaces you, that the landlord has an obligation to, in good faith, go out and try to re-rent the premises. So if you're paying $10,000 a year for the premises and there are 3 years left, so there's 30,000 total, you don't want the landlord just to sit in his hands and try to collect 30,000 from you. You want him to go out and try to lease it to somebody else. And even if he leases it for somebody who's only going to pay 25,000 rather than 30,000, that would limit your liability to 5,000 rather than 30,000. And oftentimes in this market, you'll find that the landlord can lease it for more than you were paying. So therefore, he's not harmed, and you shouldn't have to pay any of those future rent obligations. There may be some obligations for you to pay for his broker or for some advertising, but the bottom line is you shouldn't have as large a liability as long as the landlord makes good efforts and can go out and find another tenant. Landlords, on the other hand, like to put in their leases that if they evict you, all the rent for the rest of the term is immediately due, so that rather than, let's say the $30,000 was payable in $3,000 a month installments, rather than saying you owe me $3,000 now, and then if I don't get a tenant, you owe me $3,000 next month, the landlord would say you owe me $30,000 immediately today, and I can sue you for the $30,000. That we want to do away with. At best, the landlord should be able to collect from you monthly until he finds a new tenant. And that's obviously from the tenant's viewpoint. If I were talking about a landlord, I may say something different, but from the tenant's viewpoint, you want to obligate the landlord to try to find somebody else and to minimize his damages. Many times you'll be asked to sign what's known as a subordination or non-disturbance agreement. That would be with the landlord's mortgage holder. And what that basically says is that your lease is subordinate to the mortgage. So if the mortgage ever foreclosed, it could extinguish your lease. However, the mortgage holder agrees that as long as you're current in your lease, he's going to let you continue to occupy the premises for the rest of the term. So there's a benefit for you in that as long as you're current in your lease, regardless of whether the owner is paying the mortgage holder, it's not going to impact you because the mortgage holder will not try to evict you. Obviously, if the landlord is not paying the mortgage holder, there may be other issues in terms of property maintenance and the like that aren't being done as well. But the key thing with the SNDA is that the mortgage holder will recognize your lease. So read the SNDA, make sure that it says that, but it's nothing you should balk at. Force majeure, and I bring this up only because of COVID, basically. Force majeure says if there's an act of God or active war or something that prevents somebody from performing, that you don't need to perform. Performance will be delayed until the act has ceased. So, for example, if the landlord has to build out your premises, and he says he'll do it in 30 days, and there was an earthquake, and so it took him 60 days instead of 30, that would be okay. Landlords try to put in there, if there's an act of God, that you still have to keep paying the full rent, which I would negotiate against, especially as we all had our COVID experiences, where people were calling saying, the landlord won't negotiate with me, he wants full rent regardless of this or that or the other thing. We try to negotiate that while the act, and the acts now include pandemics when we negotiate the leases, that you don't have to pay full rent or any rent, depending on what you can negotiate while the event continues. So, Teresa, are there any questions at this point? Should we move on to the next topic?
I actually do not have any posted questions. We'll keep going.
Perfect. Okay. So now we'll move on to other contracts other than leases. There's a lot of people probably are working from their homes these days and don't have brick and mortar premises. Let's talk a little bit about employment contracts and whether you have an employment contract. A lot of employment would be at-will employment, which means I can leave anytime I don't like it here, and you can fire me anytime you don't want me here. Obviously, it has to be good faith here. It can't be for prejudicial reasons, race, sex, so on and so forth. But at-will basically gives discretion in both parties to terminate the relationship at any time, as opposed to a term contract, which will probably be done mostly with senior executives or senior management of your company, in which you'd agree to employ somebody for a 2-year contract. I mean, think of your athletic teams. The players are all getting term contracts for 2 years or more. And so therefore, the employee is engaged for that period of time unless he or she breaches the contract. And the contract can have all sorts of provisions that they could breach. For instance, you see in some contracts morals clauses. You see in some athletic contracts that you can't play a different sport in the off season, and so on and so forth. So, but the term contract basically is, as long as you comply with the contract, we cannot terminate you during the term of the contract. A lot of clients come to me and ask about independent contractor status. An independent contractor, unlike an at-will or a term employee, is not an employee. Excuse me. You're paying them a fixed sum to do a fixed job. You're not giving them any benefits, no vacation pay, no health insurance. You're not withholding taxes from them. It's their obligation to pay their own taxes. You don't have to pay the employer portion. You don't have to withhold Social Security and the like. The question is, who is an independent contractor? The easy thing to do is to think about, your toilet's clogged and you call a plumber. The plumber comes to you, he fixes your toilet. You pay him for his services. That's it. You're not paying, any benefits to him. You're not withholding taxes from his payment. He's in the business. You're not the only client. He has lots of clients, and can do lots of jobs. Massachusetts really requires that the direction and control be within the contractor. So for example, if the plumber comes over to fix your toilet, you're not going to stand there and tell him, let's remove this pipe and remove and replace it with this or that or the other thing. He's going to have his discretion on how to undertake the repair and what parts to use to make the job complete and whole. So he has control of performing the business, and he's doing a task that typically is not performed within your company. People, for instance, will hire a website designer to help them design a website. That's not an employee of the company. The website designer is subject to your instruction what the website should look like, just to decide how to put it together and the like. And and has his own independent business. You're not the website only client. So it's not clear. You probably are aware of the let's call it the largest fight between employee and independent contractor I know is going on with the Uber drivers and the Lyft drivers, who want to be deemed employees and not independent contractors, and the company wants to keep them as independent contractors and not pay them minimum. You don't have to pay minimum wage if you're an independent contractor. You just contract for a price. And so there's that's where the rubber meets the road. But from a small business, if you can start by not having employees but independent contractors to do specific tasks, that may save you some money. In that, number one, you don't have to pay withholding taxes, social security taxes, unemployment benefits. You just pay a fixed sum for the job. So you hire me to do your website, you're going to pay me $5,000, period, end of story. You don't have to pay taxes on top of that. And we can, our relationship's done, the employee is going to continue to be employee. If you gave me a 2-year contract and I'm sitting on my hands for 3 months and busy the other 9, you're still paying me for the other 3 months. So independent contractor may be the way, and I know a lot of startup businesses like to start with independent contractors. Now, when you hire someone, you're going to want to consider having a non-compete clause. Now, non-competes in many states are unenforceable. In Massachusetts, there's some ability to enforce them, but they're very narrowly enforced. You need to have a geographic limitation and a time limitation that's reasonable. So if I'm a lawyer in Boston, and if somebody in my office wants to move to Springfield to start a law practice, that may or may not be reasonable to prevent them from opening their own business. The purpose of non-compete is to help you not lose business to somebody else. At the same time, the society thinks that people should be able to make their living. And so non-compete can be used for that, but usually you put in a geographic limitation. For instance, you can't open your law practice within 25 miles of Boston for a year. And those can be enforced. There's a whole series of things you need to do in Massachusetts before the contract and in the contract before you can enforce them. So you really need to consult an attorney to make sure you're doing it right. Excuse me, I'm just fighting a cold here. And you have to think about who you're using non-compete for. If you have a receptionist, a non-compete with a receptionist probably isn't going to work. But if you're talking about a senior executive, that's another thing entirely. The next thing is non-solicitation, which differs from a non-compete. A non-solicitation is that you won't go open your new business and call your former coworkers to come work for you. That for a period of time, if I work for company X and you worked for company X and you go to start your own business or work for a different company, you won't call me to get me to come over to your business. And it's not only employees you don't want to solicit, you won't solicit clients. So in the law business, for example, if you were free to go open your own practice and you had a non-solicitation, you say you can't call up your clients from your former firm and ask them to come and switch to you. Now, the law firm's a bad example because clients typically follow their lawyers, but in a different business, if you're selling bathroom supplies for company X and you go and you get employed by company Y to sell bathroom supplies, if you have a non-solicitation, you're not going to be able to go to company X's customers for a period of time to solicit them to come to you in the new company. So that's another clause we like to consider putting into contracts for employment. Non-disclosure, of course, is important. If somebody gets confidential information, you don't want them to be blabbering it all over the world, whether they're still working for you or they're not working for you anymore. You want them not to disclose confidential information they receive. For instance, if they have access to your financial information, you don't want them publishing that. If you're a manufacturer and you have a process or a patented process, you don't want them to doing anything with that. So, there are exceptions to non-disclosure. For instance, if a court says you have to produce something, then you probably have to produce it. And there's some other exceptions, like if I was hiring a consultant for a SCORE client. I wasn't hiring, I was assisting a SCORE client and hiring a consultant. And, the consultant said, well, if I already knew this before I started working for you, well, that's fair. And if it was in the public domain before he knew it, he could disclose it. Compensation and benefits in a contract. Obviously, there's base compensation. Are there bonuses? Is there vacation pay? Are there sick days, times off? What else are they getting compensated for? Are they getting compensated for travel expenses or business expenses? Are you giving them a stipend to maintain their licensing? Are you paying for seminars that they're going to go to? What benefits beyond the compensation are there? And we're not going to get into compensation that's payable years down the road for work done today, but there are ways of structuring compensation as well. So these should be put out in the contract. Company policies. A lot of companies that I've worked with SCORE clients who try to develop handbooks or policy and procedures for their company so that people know what's expected of them. These wouldn't necessarily be in the contract. They'd be referred to in the employment contract. For example, the policies and procedures could say, we expect you to work 5 days a week in the office. We expect you to wear a suit and tie if you're a man, and an appropriate business suit if you're a woman. Our vacation policy is you get 1 day for every year you've worked here, whatever it may be. These would be in the company policies. The policies also generally include provisions dealing with harassment claims, whether it be sexual, racial, or whatever, and how to proceed with a claim in the company if any of these situations arise. So it deals with basically the day-to-day running of the business and the policies, which may not be in the contract. Depending upon the number of people in your company, you will want some policies that you can point to down the road if there's an issue. The last point I have is vicarious liability in agents. I just wanted you to be aware that if it's an employee as opposed to an independent contractor, that if I'm your employee and I do something wrong, the company will be responsible. And so if I go out and within my authority make a contract to buy 10,000 gift packs for the company, and you say, what did you do that for? Company's still going to be bound by it as long as it was within my apparent authority, as opposed to an agent. Like, think of a real estate agent. You're selling your house. The real estate agent has no ability to bind you. You have to agree to sell the house at a certain price, and so that's the difference between an independent contractor agent like a real estate agent versus an employee who works with you. Now, if it's not an employment contract and it's just a contract for providing services or goods or whatever, you really need to detail the services in detail, because you don't want there to be a dispute as to what you were doing for the payment you're going to receive. So if you said, for example, I'm going to provide consulting services, well, that's pretty broad. So let's assume that the company really engaged you to consult on its coming up with some standards for bonuses for employees. And then they say, and by the way, what do you think? Can you help me look at my health insurance? Technically the company would say, you're obligated to, because you said you're giving consulting services. So we try to be as specific as we can in terms of what services you're providing, so that if the client asks you to go beyond the scope of the services to which you agreed, then you have another discussion about, sure, I'll do the health insurance consulting with you, but that's going to be a fee of X in addition to what we're paying there. So you do definitely want to be as specific as you can be in terms of the services, so there's no dispute as well. Not only does it come to payment, but you don't want to dispute saying, I thought you were going to do this, and no, I was only going to do that. You really want the services outlined. And then the payment terms. How are you being paid? Are you being paid hourly? Are you being paid by the job? How often are you getting paid? How are you being paid? Do you take a check? Do they do direct deposit, Venmo, credit cards? How are you being paid? When are you being paid? If you're doing a job for somebody, are you getting a deposit up front and then you get another payment when the job's done? Or do you get, like if you're doing a construction contract, you usually get something up front, and then every month you submit a requisition, and sometimes there's a holdback of 10% in a construction contract. So you need to lay out the payment terms, not only how much, but when and how you're going to be paid. And, you'll also want to make sure that if somebody is to pay you when they don't, and you have to sue them, that you can recover interest on the overdue amounts and your legal expense in suing them and other costs you incur. Some contracts are exclusive. For instance, if I'm going to be the sole provider of baseballs to the Red Sox, I may give them a different price, because I know that during the course of the season, I'm going to sell X number of baseballs, and I know that they're pre-sold basically, because they're only going to buy from me, and I know what they use every year. Exclusive contracts are not necessarily a commonplace, but if there is an exclusive, it should be said in the contract that they're only going to buy from you. You may be selling to others than them. You may sell to the Yankees and the Orioles as well as the Red Sox, but their obligation is to buy their balls exclusively from you and nobody else. And your obligation is to supply them with the balls that they ask for. So if they ask for 1,000, if they ask for 10,000, your obligation is to provide those balls. But if it's an exclusive arrangement, meaning they can't go shop it anywhere else, it should be in the contract. Warranties. Generally, we like to provide that there are no warranties, that what they see is what they get. There are some warranties under law. If you're selling retail goods, there's warranties of merchantability and fitness for a particular purpose that you probably can't get around. But, I had somebody who was consulting parents and children on college admissions, and we put in the contract that, there is no warranty or guarantee that you're going to get into the college of your choice, or that you get into any college, and I'm just trying to help you. And because, you don't want someone to say, I applied to Harvard based on your recommendation and they rejected me, and therefore I want to sue you for breach of the contract. Just as we talked about entering into leases with buildings on an as-is basis, if you go to a store and they have goods on sale, generally they'll say as is, no refunds. They're not warranting that they're perfect. They could be secondhand or whatever, but you want there to be either a exclusion of warranties or a limitation of warranty. For instance, if you're putting a roof on somebody's house, you're probably going to give them a warranty of X number of years, but that should be it. There shouldn't be any other warranties. You're saying if there's a defect in the roof for the next 12 months, I'll come back and fix it. But after that, don't call me, I'll call you. So you really want to be very specific on what warranties you're giving and excluding warranties that you're not giving, like the guarantee of getting into a college. Indemnification provisions are also prevalent in contracts. What that basically says is that if I get sued for anything I do in performing this contract, you, the other contracting party, are going to hold me harmless and pay any damages incurred. The exclusion of that is generally if I was grossly negligent or did something willfully. So if I'm a contractor and I'm building an addition in your house, and I take my hammer and somebody comes in and I hit them on the head with it intentionally, the owner's not going to indemnify you. If I know that you need to put a supporting beam here in this place and I didn't put one there, that's probably gross negligence, because it was sort of almost an intentional fault. You shouldn't get indemnified. But in general, what you want is, I'm performing this contract for you. If anything goes wrong, you're going to pick it up, whether it be your insurance or whether it be in another place. If somebody, let's say I'm doing construction and your child walks on the premises and trips and falls on a board and hurts himself, that's going to be your problem, not mine. As long as I'm not grossly negligent or acting intentionally, you should bear the risk. A lot of contracts, and I will preface this by saying that I personally never liked this in contracts when I was practicing law, say that if I do something wrong and I'm responsible, you can't recover more than you paid me. So, for example, let's assume I gave you a service for $1,000 and I did something wrong. That means I'm liable, and it cost you $1 million in your business. Even though you paid me $1,000, the cost to you was $1 million because it was a severe consequence of my having done it wrong. What limitation liabilities will say is you can collect $1,000 from me, even though you lost $1 million, you can only collect $1,000. You can see why I didn't really like that, but that isn't a lot of contracts. A lot of contracts I review, a lot of contracts I work with score clients on, which is if anything goes wrong that I'm responsible for, you can't collect more than you paid me. You know my feeling on that, but obviously I counsel people to put it in if they can get away with it. Dispute resolution. If you have a dispute with a party to the contract, are you going to go to court? Are you going to try to, presumably you always try to work it out amongst yourselves, but if you can't, you go to mediation, where you each present your side to a mediator and he recommends how to be resolved. And that's not binding. So if the mediator says, I recommend that you pay them $10,000 to resolve the case, you can say, no, I'm not going to do that. You go to arbitration, which is a little more expedited than going to court. It still can be costly, but You can go to arbitration, and the arbitrator can say, okay, I'm the judge here, and this is what I think should happen. And generally you have it as binding so that the arbitrator's decision can be enforced. Or you can go to court, but you need to decide, how do you want to resolve disputes? Going to court would be my last recommendation, just because it's expensive and time delays. So a lot of people put in arbitration clauses because it gets it heard in a more expedited manner. So those are just some of the highlights of things that I think about putting in contracts when I do them. Teresa, do we have any questions before I move on?
Sorry. Sorry, my thing's covering up. Okay, what if one damages something outside the contract that's expensive that can be litigated?
Damages something outside the contract. Can whoever asked the question be a little more specific? I'm not sure I have the whole gist of it.
Okay. The second question, we're going to hold till the end because it's not related to what we've talked about so far.
Okay.
And then, for the installation of a water, like this person must install water leak sensors, and that comes with its own warranty on the product. Are you required, to have a warranty on the labor?
Required to? No, but generally, I assume that people expect that if you install it incorrectly, that you're going to come fix it. And so, you know, there may be an implied warranty that you installed it correctly, but you don't have to give an express warranty saying, you know, I guarantee the labor for 2 years. But if it fails in the next couple of days, you know, I think there'd be an implied, or the court would find an implied warranty that you warranted you installed it correctly.
Do you recommend error and omission insurance for marketing freelancers?
I probably would, and the reason for that is I would with its qualification. Think about what you can be sued for. You know, errors and omissions. You know, you can make an error or do an omission. So I would probably recommend that. I don't know what the cost of that would be. That's another thing to consider. You know, when we talk about insurance, you know, I'm generally in favor of insurance, but there's a cost benefit to insurance too. I always like to tell people, they'll give you one page saying we insure you for this, and then they'll give you 25 pages saying, but it doesn't cover all these things. So you got to really read the policy carefully, and you have to look at your experience as well. I mean, some people have said to me, you know, I've been in business 10 years and I've never had a claim like this. And I say, well, then, you know, maybe you're comfortable not getting that kind of insurance. But a lot of people like to have the backbone of insurance to protect them. You know, the theory being, if they have the insurance, there'll never be a claim. And if they don't have the insurance, they'll get a claim against them. I mean, there's no legal theory to that. But I would recommend the insurance, but I would also want to think about my experience in terms of what claims have I seen out there, either in my business or in other similar businesses, and you know, what's the amount of risk there, and how much insurance do I really need? Because if you see the risk as being a $50,000 risk, you know, you don't want to necessarily buy $1 million of insurance. So you got to assess the amount of the risk, the likelihood of the risk, and read the policy to make sure of the exclusions, that you're not buying something but not getting what you think.
Okay. The previous question, it was a follow-up to the what you said about not being able to sue for more than what they paid.
Oh,
what
right.
if you damage other things?
All right. So let's take an example, and if this isn't right, please follow up with the follow-up. So let's assume you're installing a gas pump or a gas tank in a service station, and you install it incorrectly, and oil leaks onto a neighbor's property. The limitation wouldn't apply to the neighbor being able to sue you for the cleanup costs because of your faulty installation. If, for example, you're doing a construction job on somebody's house, and you let me think of an example here. And you back your truck into their garage, you know, I'm not sure that the limitation of what they paid you would apply. The limitation really applies to the service you're providing. So if you're putting in a new bathroom for them, and you put it in and there's a problem with it, with the bathroom, then the limitation would apply. But if you did something else, it wouldn't necessarily apply because it's not arising out of the services for which you were engaged.
I'm going to hold the rest of the questions. So go ahead and
Okay.
finish up.
Okay. All right. The well, let's deal with insurance, since we were just talking about insurance. Key man insurance. As a startup, you're probably not going to have key man insurance, but as your business ages and grows and you have some key employees, you may want to consider buying insurance policy on those key employees. For example, let's assume you're in business with one partner, and that partner, his job is to generate business, and your job is to service the business. Well, if the generator becomes disabled or dies, you're going to have to find a way to pay him out as your partner, and then you're going to have to find a way to replace his services. So there's like a double whammy there. Keyman Insurance would say that if he were to die, that basically the insurance company would pay him out for his value in the company, and that wouldn't cover your having to go out and find a replacement to generate the business, but it would deal with paying somebody out. So as your business grows and becomes more valuable, and you have key people who are essential to that business, you may want to consider getting a key man policy so that the business doesn't have to use its cash to pay out his estate if he dies. As I said, that's usually not an issue for startups, and because the value isn't there yet. But you can imagine if you have a Microsoft, and that's probably a bad example, and the key person died there's going to be a big payout to the key people, and you may not want to take that out of the company's coffers. And that's why Microsoft's a bad example, because their coffers are pretty big, but a smaller company. You'll want to get a personal injury and property damage insurances, like comprehensive commercial policy, so that it will cover if you injure somebody or you deal with property damage in the business. So for example, I'll give a real example. My car was in the shop for repairs, and a carrier truck with other cars on it just backed and went right over my car. So obviously I was taken care of, but what the company had who was servicing my car had property damage, so they had insurance to cover the damage that they or their shop caused to my property. And personal injury would be if somebody got injured, if rather than running over my car, if that carrier had hit me and I was injured, they would have personal injury insurance to cover that. Like all insurances, you can discuss deductibles. How much can you foot out of pocket? The more you can foot out of pocket, the smaller your premium will be. So that if you say I can pay $1,000, the first $1,000 for any injury, that's going to be different than if you say I can only pay the first $500 for any injury. Also, personal injury and property damage is usually limited to an amount per accident and an aggregate overall amount. So if it's $1 million limit on property damage, and you have 5 claims for property damage of 200,000 each, that's your $1 million limit. The 6th claim would not be covered in that year. And it's important to note that most of the policies are an occurrence basis. So if the claim occurred in the year of the policy, the insurance company will take care of it. But if the claim is made in a different year, in a claims made policy, the claim has to be made in the year that it was covered. So there's difference between occurrence and claims made policy. So you need to understand, what does your policy cover? And and a lot of times you try to get a tail on the policy so that it covers a period after the policy is over, especially if you're switching agencies and companies in the year. You try to get a tail on the old policy. Product liability, that's a separate policy you'll get if you're, I always use the example, if you're selling food and somebody gets food poisoning, you want to make sure you have insurance for that. If you're selling manufactured goods and somebody gets injured by using your manufactured good, you want a claim for that. So that's a separate insurance that you should be getting. Business interruption insurance, there was the big dispute on this in COVID, because what business interruption says is if your business can't be run, we're going to pay you your losses. So, for example, the easy one to discuss is, if there's a fire and you have to close your business down for 90 days while you refurbish the building and make it habitable again after a fire, business interruption should pay for the losses you incur during that period. If your normal sales are 10,000 a month and your normal profit's 5,000 a month, they should pay you 5,000 a month plus presumably any expenses that you had to pay, like rent, or if you had to pay rent during that month, or if you have people under a contract, or so on and so forth. However, during COVID, there was a big issue because the insurance company said COVID wasn't covered by business interruption insurance, and there were lots of litigation about that. People also asked me about umbrella policies. I had an umbrella policy. My firm had malpractice insurance that covered me, but I had a personal umbrella policy, so that to the extent my firm's insurance was insufficient, I had my own policy to cover any excess over the firm's policy. Depending on the business you're in and you're comfortable with the company's underlying policy, you may want to get an umbrella policy to cover the risk that the company's policy is insufficient to cover you. Moving on to intellectual property, we get a lot of questions at SCORE about this. The first thing that we'll talk about is trademarks. Trademarks could be your name, it could be a logo, could be a design. Like a McDonald's, the yellow M, that's trademarked. And you can have a state or federal trademark. I would definitely recommend federal, because the state only would protect you if you only had a Massachusetts trademark. It would only protect you in Massachusetts, and somebody could use the same mark in Maryland, for example. You can go to the United States Patent and Trademark Office, USPTO site, and you can do a search to see if what you want to protect has already been protected, because they're clearly not going to allow you to protect something that somebody else is already using. The purpose is to avoid confusion. And so if, for example, I just had somebody who wanted to use the mark Hollywood on something, and if it was Hollywood groceries, it may be different than if it were Hollywood pictures, because the use was different. So they may have been able to get the Hollywood groceries protected because it's not used in the same vein as Hollywood pictures, but you can go search the trademarks, see if somebody's using it, and then file an application for the trademark. There'd be either a use, meaning you're actually using the mark, or an intent to use, meaning you're going to use it in the next X number of months. So trademarks are I won't say easy, but they're the easiest of the intellectual property to protect. Patents and copyrights, there is the patents is the United States Patent and Trademark Office. Obviously, that's there, and the copyright is the U.S. Copyright Office. That's a little more. You're going to definitely need help with your patent, because your patent is for something you've manufactured or designed, and there's usually a lot of back and forth on that. And a patent is limited in time as well. But think that you do a widget, and somebody else comes along and tinkers with it and makes one change in it. Is that covered by your patent or not? Well, they say it's a different product because I made this change to it. You really need counsel for patents and copyrights. If you're writing books or copywriting materials that you're passing out, you'll need assistance with that. I basically you absolutely need help to protect it. Now, if the key thing is, if somebody's working for you, if an employee develops something, a patent or copyrights some materials, generally your contracts are going to provide that this belongs to the company, because he did it while in your employ, whether he did it during company hours or after company hours. If it was in your employee, you'd want it to be what's known as a work for hire, so that it is the company's property and the employee has the right and obligation to assign that to the company. So you would cover that in your employment contract with your employee, that whatever he develops while employed by you is yours, and he'll cooperate to make sure that it is properly assigned to the company. Now, all of the trade secrets really are things that are unique to your business. Let's say you have a special formula for developing chicken soup that nobody else has. That's a trade secret. You don't want one of your employees who helps you make the soup to go off and disclose that or use it with somebody else. So the contractual protections we like to have a strong non-disclosure agreement, confidentiality agreement, in which people who have access to your trade secrets, patents, copyrights, whatever they may be, will not disclose them to anybody else, and will use them only for the purpose of furthering your business, and won't sell them or publish them or do anything with them. So it's very important, if you're dealing with patents, copyrights, or trade secrets, that you have an employee, even if he doesn't have an employment contract, if he's just an employee at will, or if he's even an independent contractor, to sign a confidentiality provision that limits their ability to disclose items, to use items for other than your purposes. Teresa, I see I've gone over here, so let's take some more questions.
Okay. We are not going to get to all questions, and some are very personal, and certainly would be better handled on one-to-one with a mentor. But I thought this one was could apply to multiple people. This person has a glass studio, and she has the students sign a release in advance so she doesn't get sued for slip and falls or accidents with the glass. Is there any other thing that you can suggest that they should do as well? Is having that release form enough?
Right. I mean, I'd want to see the release form to make sure that it is broad enough, but basically it's you're saying you're assuming the risk that this is an activity in which you could be harmed, and you understand that, and you're assuming the risk and not going to come back at me with any claims. That, I think, if it's drafted properly, would be more than sufficient. It's like, we probably don't know, we go to a sporting event, the back of the ticket has an assumption of a risk saying, you may get hit by a flying puck or a baseball or something else, and that's your risk. You're coming to the game assuming that risk. And so I think that that is fine. I do think that to the extent, again, that you do something intentionally, you take a piece of glass and break it across their arm and cut them. I mean, that's probably not going to be covered by assumption of risk, but the normal everyday operation of the business, the assumption of the risk and release of the company, I think is sufficient to start.
Is a logo like a badge considered a trademark or a copyright?
A logo would be considered a trademark.
Okay. There are some questions about LLC and how much that protects you. I do strongly encourage you to check out the previous legal webinar. The recording is on the website. And if you have any further questions, to come back to us. Let's see. I think that's where we're going to end it today. So I want to thank everyone for joining us today, and to David for, he always provides just so much information that it's a lot to absorb, we know. So definitely come back to us, ask for a mentor, reach out, and we can get you scheduled with somebody to get your questions specifically answered. As he mentioned at the beginning, we can't offer direct legal advice, but we can certainly send you in a direction. So thanks, everyone. Thanks, David.
All right. Thank you.
Bye.